Hey everybody, how's it going? Welcome back to Copper Jacket TV. So just one day after oral arguments at the Ninth Circuit Court of Appeals in Nguyen v. Bonta, which is a case that challenges California's 1 in 30-day firearms law, which is essentially a 30-day prohibition, we have a decision. We just got an order from the Ninth Circuit Court of Appeals, and it is massive. How often do we get to say we got a win at the Ninth Circuit? So we're going to talk about what happened and what this means for everybody within the Ninth Circuit's jurisdiction. So let's talk about what's going on here. This video is proud to be sponsored by American Hartford Gold. Listen, if there is one thing that those of us in the firearms community understand, it's that you cannot rely on the government for your protection. Not with your life, and especially not with your wealth. Look, throughout our lifetime, the dominance of the US dollar was unquestioned, but that may be changing. As we face unprecedented inflation, the world's biggest economies are ditching the dollar for the yen. Banks are failing left and right, and the government is discussing a total control of all of your money with the new digital dollar. Don't let your life savings become a casualty of failing corporations or currency wars. Now is the time to call the only precious metal dealer that I trust, American Hartford Gold. They'll show you how to protect your savings and retirement accounts by diversifying your wealth portfolio with physical gold and silver. With the finest products, amazing customer service, and a buyback commitment. American Hartford Gold has a 5-star rating from thousands of reviews and an A+ from the Better Business Bureau. American Hartford Gold supports content like this that is committed to bringing you the truth. Tell them I sent you and they'll give you up to $5,000 of free silver on your first order. So call them now. Click the link in the description or call 866-856-2507. That's 866-856-2507 or text COPPER to 65532. Again, that's 866-856-2507 or text COPPER to 65532. Okay, so let's go ahead and talk about what's going on here with this massive victory at the Ninth Circuit Court of Appeals in Nguyen v. Bonta. Now, in order to have a little bit of context, we're going to back it up just a bit, but I'll try and make this fast, okay? So back in March, we actually got a victory in this case at the district court level. So at the district court level, we got the win. California obviously doesn't like that very much. So they filed for an emergency appeal pretty much the same day. That's just the way that California works. Now, they asked the Ninth Circuit for a stay of the district court judge's order. Now, when you ask for an appeal like that, it goes up to a special 3-judge panel, basically an appeals panel, right? And these 3 judges take a look at things and they decide whether or not to grant the stay or to let the judge's decision stand. And that went up, and guess what? We actually lost that one in a 2-1 decision. So there was 2 judges that said that they thought the state was likely to win in this case. We had one dissenting judge, Judge Nelson, who said it's clearly unconstitutional. He absolutely disagrees with the other 2 justices, and he would not grant the stay. Regardless, there was a stay placed on the district court judge's order, and then it was sent up to a 3-judge panel of the Ninth Circuit to be reviewed on its merits, right? So this is where they dive a little bit deeper. When it goes up for an appeal, they kind of work a little bit quickly. They don't really deep dive into everything in its constitutionality and oral arguments and stuff like that. That happens later. That's what happened with the oral arguments just a couple days ago. Now, in the video that I made the day of oral arguments, so just a couple days ago, I was talking about how embarrassing it was for the attorney for the state of California. He pretty much had no argument. There was no relevant historical analogs. There was really no way to argue his case. He was kind of backed up against a wall because it was so clearly unconstitutional. Well, apparently the 3-judge panel at the Ninth Circuit saw the same exact thing, and it was a unanimous decision. Now, we're talking about 2 conservative judges and 1 judge that was appointed by Obama, and even that, we still got all 3 agreeing that the plaintiffs have a likelihood of success on the merits, and they allowed the district court judge's order to remain in place, and they lifted the stay by the appeals panel. So, I mean, that was huge. And we're talking one day. You guys know, if you watch this channel especially, nothing happens fast at the Ninth Circuit, especially when it comes to Second Amendment related topics. They drag things out for as long as possible. But this was such a clear violation of your constitutional rights that all 3 judges said absolutely not. We're going to allow the district court judge's opinion to remain. So what does that mean for you now? Well, I'm happy to say if you live in the state of California and you were burdened by the 1 in 30, which I think most people were, it's gone. As of right now, that law is not enforceable. It does not exist. So if you wanted to go in and say 3 lowers or 2 of these or 4 of those, whatever, you could do that. There is no 1 in 30 law in the state of California at this time. So this obviously can and more than likely will be appealed, but I actually don't think that they are going to take it on appeal because of the unanimous decision of these judges. I think that it is so clear-cut and indefensible that I don't think that the en banc panel is going to want to take this on. Plus, you consider the fact that you have 3 judges right now who say that it's unconstitutional, and they think that the plaintiffs are going to win. And then you have Judge Nelson, who was the dissenting judge in the previous decision. That's 4 judges on the Ninth Circuit already that say that the plaintiffs have a likelihood of success on the merits. That's 4 judges as we stand right now. And so that is going to be a main contributing factor to whether or not the Ninth Circuit actually takes this case up. They're going to have to look at all of that in their consideration. I personally think that they're just going to let the district court's decision stand, and that's going to be the end of the 1 in 30 in California. Now, I don't have a crystal ball. I always say that. I can't see into the future. This is just my prediction, but just in case, if something does happen, they decide to, grant it en banc, and they decide to maybe drag it out a little bit just for the sheer, time delayed tactics of everything, that means that there could just be a very short window in order to enjoy the 1 in 30 being gone as of right now. So again, it's one of those things where it's a game. Do you wait? Do you not wait? Do you run out right now, or see what happens? We're kind of back to one of those. But again, my prediction is that they're not going to be able to take this en banc. I think that this is just the end of the 1 in 30 in California. And because this was a Ninth Circuit decision, any other state that would try and do something similar to this, that is within the Ninth Circuit's jurisdiction, wouldn't be able to. So this pretty much alleviates any 1 in 30s within the West Coast. Now, obviously, I'll keep you updated. If anything changes, I will let you know. Make sure you hit that subscribe button if you're not subscribed already. Little bell notification will let you know when new videos come out. And I just want to say congratulations to the FPC, congratulations to everybody that's involved, and congratulations to freedom. It is about time that we see a victory, and I have a feeling we're going to see a lot more in the next year or two. I think you guys are going to see some major changes. So anyway, I wanted to let you guys know about that. Hopefully that makes your day and your weekend a little bit better. You guys have a great one.